5 seconds. Start. It is thus settled law that normally when an appointed authority or the disciplinary authority seeks to suspend an employee pending inquiry or contemplated inquiry or pending investigation into great charges of misconduct or defalcation of funds or serious acts of omission and commission, the order of suspension would be passed after taking into consideration the gravity of the misconduct sought to be inquired into or investigated and the nature of the evidence placed before the appointing authority and on application of the mind by disciplinary authority. Appointing authority or disciplinary authority should consider the above aspects and decide whether it is expedient to keep an employee under suspension pending aforesaid action. It would not be as an administrative routine or an automatic order to suspend an employee. It should be on consideration of the gravity of the alleged misconduct or the nature of the allegations imputed to the delinquent employee. The court or the tribunal must consider each case on its own facts, and no general law could be laid down in that behalf. Suspension is not a punishment, but is only one of forbidding or disabling an employee to discharge the duties of office or post to avail further opportunity to perpetrate the alleged misconduct or to remove the impression among the members of service that dereliction of duty would pay fruits and the offending employee could get away even when pending inquiry without any impediment, or to prevent an opportunity to the delinquent officer to scuttle the inquiry or investigation, or to win over the witnesses or the delinquent having had the opportunity in office to impede the progress of the investigation or inquiry, etc. It would be another thing if the action is actuated by malafide, arbitrary, or for ulterior purpose. The suspension must be a step in aid to the ultimate result of the investigation or inquiry. The authority also should keep in mind public interest of the impact of the delinquent's continuance in office while facing departmental inquiry or trial of a criminal charge. In the case in hand, the allegations by itself are quite serious, but it does not appear as to whether the respondents themselves have made any kind of inquiry or any investigation or inquiry in the alleged criminal offence of the petitioner. The respondents have not even whispered in the entire counter affidavit that they collected any material from the said news channel or otherwise found that the matter requires some investigation or inquiry against the petitioner in respect to any alleged criminal offence, though it is said that they have referred it to CBI, but whether any case has been registered by CBI for making investigation or inquiry into an alleged criminal offence has also not been stated in the counter affidavit. The investigation or inquiry into an alleged criminal offence would come only when an FIR or criminal complaint is registered. Thus, in our view, the order of suspension has been passed without satisfying the requirement of Rule 10(1) of 1965 rules.